Good morning, good afternoon, and good evening. Welcome to the webinar, Combating Originalism in State Courts. This program is sponsored by the ABA section of Civil Rights and Social Justice and is part of Part 5 in the Reproductive Rights and Justice Committee's In Conversation series, exploring the complex and rapidly changing legal landscape of reproductive rights in the U.S. CRSJ is actively planning additional programming on a variety of reproductive rights and health topics. So please visit us at americanbar.org/CRSJ for updates on these programs. Today, we'll be talking about combating originalism in state courts. From the rise of originalism in constitutional interpretation to the landmark Dobbs v. Jackson Women's Health in 2022, courts have increasingly relied on this legal philosophy to justify the rollback of reproductive rights and other important rights. However, recent state court rulings in North Dakota and Georgia demonstrate how constitutional protections at the state level are being used to challenge originalist arguments and safeguard individual rights. These cases highlight a growing resistance to originalism and its implications for reproductive autonomy. I'm excited that you'll be joining our experts as they examine how the North Dakota and Georgia cases push back against originalist interpretations of the law and explore why these legal battles matter. We'll discuss the judge's reasoning, the broader implications for reproductive rights and other rights, and how state constitutions are becoming critical tools for protecting privacy and liberty in the post-Dobbs landscape. This discussion will provide a comprehensive look at combating originalism in the courts, unpacking strategies and insights for advancing reproductive justice, and challenging regressive legal frameworks. My name is Araceli Munoz, and I serve as chair of the ABA's Reproductive Rights and Justice Committee. And I'm excited about today's guests. And without further delay, I will turn it over to them to introduce themselves. And I'm going to start with you, Diana.
Thanks, Araceli, and thank you so much to the ABA and the committee for producing this. I'm really excited to be here. So I'm Diana Casson. I'm the Legal and Policy Director at the Center on Reproductive Health Law and Policy. And this is an independent think tank and research center at UCLA Law. And we're developing lasting solutions to advance reproductive rights, health, and justice, and to address the current national crisis of abortion access. Our lawyers, policy experts, scholars, and researchers are working to increase access to abortion and contraception, to end racial and economic disparities in maternal health outcomes, to support people who decide to build families, and to dismantle the gender bias that limits reproductive justice. And we're really committed to driving long-term solutions along with immediate support to advocates, providers, and policymakers. So we seek to have an impact over the long term and right now in 4 key ways. First, we're marrying long-term legal thinking on rebuilding reproductive rights with empirical research about policy models and impacts that help people today. Second, we're looking at how to bridge disciplines. We're translating knowledge and improving strategy across sectors within the movement by convening advocates, researchers, legal scholars, and policymakers. Third, we're focused on promoting novel solutions that support pregnancy health and family building. So we study and promote policy innovations that address care affordability and family economic well-being as well. And finally, but perhaps most importantly, we're training the next generation and expanding legal services. We train students at the law school through courses, externships, and scholarships, and we also manage a very extensive pro bono lawyer network that can assist people seeking legal advice and providing access to reproductive health care. So I think that about sums it up for me. I guess I will pass it to Mitra.
Thanks, Diana, and thank you to the ABA for having this panel and for inviting me to be part of it. My name is Mitra Medisa. My pronouns are she, her, and I am a senior staff attorney on the U.S. litigation team at the Center for Reproductive Rights. The Center for Reproductive Rights is a global human rights organization of attorneys and advocates working to ensure reproductive rights are protected in law as fundamental human rights for the dignity, equality, health, and well-being of every person. With our work across continents, we've played a crucial role in securing legal victories before national courts, before United Nations committees, and regional human rights bodies on reproductive rights issues, including access to obstetric care, contraception, maternal health, and safe abortion services. The Center uses the power of law to advance reproductive rights as fundamental human rights around the world and envisions a world where every person participates with dignity as an equal member of society, regardless of gender. I sit on our U.S. litigation team, where we challenge restrictions and bans on reproductive health care, including abortion, contraception, and maternal health care around the country.
Great. Well, thank you both for introducing yourselves to our audience. So I want to jump right in. Diana, can you explain what is originalism? We hear a lot about it, we read about it, but what is it?
Okay, sure. I think first of all, to be clear, originalism is a theory invented by the conservative legal movement. It's not from historians. It's not even from judges or case law, really. And there's various strains of originalism, but in simple terms, it directs judges deciding cases today to determine through various historical evidence and sources how those who ratified the Constitution hundreds of years ago would decide to apply constitutional principles to problems and cases in the courts today. And it's fairly new. The conservative movement made a real organized push to normalize originalism within the legal academy starting in the 1980s. It was intentionally advanced to achieve certain legal and policy outcomes through the courts. And it's laying claim to constitutional history and tradition as a way of grounding judicial decision-making. Now, of course, history and tradition has always been very relevant and important to informing how courts interpret law. But originalism really goes much further than that. It insists that courts must discern the Constitution's, quote, original meaning in order to decide how constitutional principles apply today. And the Supreme Court's taken this up in a way that I would say ignores complex and unclear histories and debates about constitutional meaning and selectively chooses and picks from incomplete histories, examples of antiquated laws, historical dictionaries, and other evidence of so-called a singular original public understanding of our Constitution. So in this way, it's become a bit of a tool to limit constitutional rights and guarantees to fit a social and political agenda that adheres to certain views and prejudices of the earliest generations. And more specifically, it's limited to those who had political citizenship and power at the founding and really controlled the creation and interpretation of laws at the time. So that is a very brief overview of how I would describe originalism and how it's used in the courts.
So how is it showing up in the courts, though? How is it showing up in federal court decisions, for example?
I think it comes as no surprise that Dobbs was a major decision that advanced this form of so-called jurisprudence. It was the first time we saw a majority of the court really fully embrace this originalist approach to the history and tradition standard, which did exist before. And as we all know, it overturned longstanding precedent recognizing the right to abortion as protected under the 14th Amendment liberty guarantee. So in addition to the devastation this has caused for pregnant people and families, it's really been destructive to the underpinnings of other substantive liberty and equality rights also protected under the 14th Amendment. And especially problematic is this, I would call, originalist language in Dobbs that says rights that are deeply rooted in our history and tradition can only include practices or rights that were, quote, recognized as positive rights under law at the time of the founding, or at the time of the 14th Amendment, I should say. So even if we could see and show the court with historical evidence that people understood and widely recognize a practice or activity as part of their personal liberty and beyond state control, if there's no positive laws affirming that, then under this doctrine or this version of originalism, those are not deeply rooted. This also means that laws and views that were used to deny women and Black people and others their liberties and rights are going to be legitimized as part of our constitutional history and tradition that needs to be followed today. So this is the broader project of originalism that we saw in Dobbs, and it's really undoing decades of progress in other areas as well. I can name examples. We can come back to them. You're nodding. I'll say, we already saw this in the affirmative action case. Yeah. So Students for Fair Admissions, I think people listening to this will be familiar with it. It was an equal protection case about race discrimination. And like Dobbs, it rolled back a half a century of precedent. It was in fact ahistorical, right? It claimed that the 14th Amendment requires laws to be race blind. But this, and Justice Jackson really addresses this in her dissent, as do other of the justices, this ignores abundant historical evidence of the Reconstruction Amendment's purpose, right? This was to protect and empower previously subordinated people, enslaved people, including through government solutions that were race conscious, not race blind. So that's just one example of this originalist approach showing up actually in a different area, equal protection. The Second Amendment is another big one. They use originalist approach in Bruin, and the court held that a gun regulation is going to be presumptively unconstitutional unless the state can point to, and I'll quote this, a well-established and representative historical analog. And then this should apply faithfully the balance struck by the founding generation to modern circumstances. So the result's been to protect gun ownership as a founding generation value and to tear down all manner of reasonable regulations needed to protect the lives of people today. And the absurdity of that was really exposed last term in the Rahimi case because the court wrote itself in circles to uphold a federal regulation that temporarily disarmed domestic abusers if they were subject to domestic violence restraining order. So not surprisingly, almost none of the justices wanted to strike down this really important life designed to save lives. Only Justice Thomas dissented, but Gorsuch, Kavanaugh, and Barrett all wrote separately to really try and explain why Bruin and originalism still made sense, even though this law could be upheld despite the complete lack of such analogs at the founding. So they really kind of tied themselves in knot to say this law, while different than analogs at the founding, is valid under the Constitution. But if you took Bruin to its logical extension, it's, it might have reached another outcome in a different kind of case.
Great. So, Mitra, we've been talking about this at the federal level, but how is originalism impacting the way you and the litigation team at the center are bringing litigation in the states?
So in states where the state Supreme Court has adopted an originalist approach to interpreting its state constitution, we have had to present historical evidence to courts to support our claims and in support of reading those provisions broadly. And there are different kinds of historical evidence that we've been looking to and have presented to courts, which relate to the history, and I guess rather, one category of those is documents that relate to the history of how the state constitution was drafted and adopted. Many states have explicit broad protections in their constitution for inalienable or natural rights, which include things like a right to life, a right to liberty, or a right to safety. Some of these protections date back to the founding of this country, and in the case of the right to life, that can be traced all the way back to the Magna Carta. So if a court is trying to decipher the original meaning of constitutional provisions, we do sometimes have to present this legal history of where these provisions came from and how they ended up in a particular state constitution so that there's context for what those were intended to mean. And additionally, in looking at the history of tradition or history and tradition, specifically in abortion cases, many states did have abortion bans in place in the 1800s, but to really get the understanding of what it means that those bans existed, they need to be placed in some context as to why they were passed, how they were enforced, how the exceptions were understood. And so we have presented information related to that as well, and that comes in various forms. So evidence related to a lack of prosecution to show that these bans were not really enforced, and certainly not in situations where people were not grievously harmed during an abortion. We've also presented medical evidence from medical journals in some states to show that even when an abortion ban was in place, physicians understood that they could still provide abortions, and they understood that to be part of their job to provide that for certain medical conditions. And they spoke pretty openly about providing abortions in medical journals at times. And so that is also part of the history that we are trying to present in these cases when courts are trying to look at what the original public meaning was at the time when those constitutional provisions were adopted. I'm not a historian and neither are my colleagues on our litigation team. So when we want to present that evidence related to the history of how these bans were in place and how they were enforced and how they affected people, we've had historians serve as experts to provide that evidence to the court. And that typically involves having a historian do some research and look into what was happening in a particular state and then present that evidence to the court. And I'd say that has been probably one of the biggest changes as we've seen more of a shift toward an originalist framework.
Whew, that's a lot more work to add to the plate when already bringing a case. So, this has changed the way you're presenting cases. How have state courts responded to originalism and some of the decisions you're seeing?
So I would say some states have adopted an originalist approach, but there definitely has not been a wholesale adoption of the originalist framework. And even in some states where state Supreme Courts rely heavily on the original public meaning and looking at the history and tradition at the time that the state constitution was adopted, Courts have looked at that history and kind of used it as a guide and context in framing their decision without necessarily restricting the rights that citizens have under the state constitution to those that they would have had at the time that the Constitution was adopted. And to give one example of this, we have a case in Georgia challenging an abortion ban there that we brought along with our partner organizations, challenging a 6-week abortion ban in state court. In a decision from earlier this year, the trial court found that the ban is unconstitutional for multiple reasons, but partly because it violates protections for a right to liberty or privacy. In reaching that conclusion, the court considered the history and context of those protections for liberty rights protected in the state constitution. And over the course of its history, Georgia has had many constitutions, I think 10 separate constitutions, but since its 5th constitution in 1861, those constitutions have had protections for life, liberty, and property. The court acknowledged that there would be, a real problem with looking at what the law said in 1861 and freezing people's rights based on what they were at that time. And I think the court explained it better than I can, so I'm just going to read a couple lines from the opinion. And the court said, quote, "The obvious problem with this interpretive approach, being originalism, is that the plaintiffs whose rights are at issue in this litigation had no or very limited rights when the constitutional provision was adopted. Liberty for white women in 1861 did not encompass the right to vote and thus to ratify the state's new constitution. And of course, liberty did not exist at all for Black women in Georgia in 1861. Thus, any rooting around for original public meaning from that era would yield a myopic white male perspective on an issue of greatest salience to women, including women of color. Certainly, that is not what constitutional interpretation of any legitimate stripe ought to do." So that was a long quote, but I think the judge really hit the nail on the head of, we can look at the context in which this constitutional provision was adopted in 1861 and who was voting for it, and use that also as a guide in determining, okay, how much are we going to rely on the history of what was happening then? And we had a similar result in a challenge to North Dakota's total abortion ban, where the trial court similarly looked at the history and tradition that was in place when North Dakota's constitution was adopted in 1889. The court acknowledged that the men who wrote and enacted the state constitution likely did not have abortion rights on the top of their minds when they were considering what the state's inalienable rights clause meant. And as in Georgia, the court looked to history as more of a guide. And again, I'll keep this quote shorter, but it said, quote, "If we can learn anything from examining the history and prior traditions surrounding women's rights, women's health, and abortion in North Dakota, the court hopes that we would learn this, that there was a time when we got it wrong and when women did not have a voice. This does not need to continue for all time, and the sentiments of the past alone need not rule the present for all time." And so what we're seeing in these decisions is courts looking at the broader context of what was going on when constitutions were adopted, whose rights were more broadly recognized in society, and who had a role in making decisions about the society. So still using history and tradition in a sense, but using it to inform their decision rather than using it to freeze people's rights to what they were at a particular point in the 19th century. And one more point just about both the North Dakota and Georgia constitutions, which I think is just an interesting feature of state constitutions that's a bit different from the federal constitution. So both of these constitutions underwent some amendments in the 1980s, which were relevant to the scope of the rights that could be protected under the state constitution. So in Georgia, as I said, they had multiple constitutions, the last one of which was ratified in 1982. And in North Dakota, the constitutional provision that protects a right to life, liberty, safety, and happiness was amended in 1984, in part to change the word men in that provision to individuals, so that it now reads, all individuals have these rights. So both of these amendments happened during an era when there were broad federal protections for abortion rights and when abortion was legal in those states. And so, state courts state constitutions in general are often much easier to amend. They often have been amended a lot more recently and had more changes. And so when you're thinking of a strict originalist approach, that's also a factor that state courts have looked at when you're looking at the original public meaning. perhaps you need to consider both what it meant when the provision was adopted and when it was most recently readopted, re-ratified, or amended. And so it kind of presents a little bit of nuance that isn't always as present in some of the federal cases, given that the federal Constitution is so difficult to amend.
And just to be clear for our audience, the two decisions that you shared with us from Georgia and North Dakota, those were not state Supreme Court decisions, or were they?
That's right. They are not state Supreme Court decisions. So those are both from state trial courts, and I believe both of those decisions are on appeal right now, but theirs are from the trial courts.
Great. So Diana, jumping off of where Mitra has left off, how have state Supreme Court opinions pushed back, if at all, on originalism?
Yeah. Well, I think the way Mitra described the pushback she's seen in the litigation and the lower court levels is exactly the same thing we've seen from state Supreme Courts when these cases do get there. And I'd emphasize that before Dobbs, courts were already called on to interpret state constitutions and determine their own judicial approach, and plenty did, right? Lots of state Supreme Courts recognized abortion was protected and is protected under the state constitution prior to Dobbs, and those decisions stand today. And actually, one of them was perhaps one of the most influential, I think, today, and lots of these state courts then cite to each other and rely on the analysis and approach. So they can be very influential, and so can the lower court decisions and even dissenting decisions. These are all kind of roadmaps to other state courts as they begin to grapple with this. But importantly, some of them do outright reject originalism. I think Mitra really accurately laid out how courts are being much more nuanced in the states and saying even when we look to history and tradition, we do it differently. And here's why, because we're in particular really worried about further subordination of historically and still marginalized groups. And we're not going to make that our constitutional value. So I would just say, Kansas in 2019 recognized a fundamental right to abortion under the state constitution in a case the Center for Reproductive Rights litigated. So, they have seen huge impact from that. And that court said, we cannot be tethered to prejudices from 2 centuries ago. And that decision post-Dobbs has continued to protect access and resulted in other decisions from the same court and lower courts in Kansas based on that standard. Looking past the Dobbs decisions and how state Supreme Courts have responded in light of that, I think we've seen even more kind of explicit responses to the problems of originalism in courts that have said, we don't even apply originalism, not, we're doing history and tradition differently, or at least, suggesting that. So I would point to the state Supreme Court decision from Pennsylvania, Allegheny Reproductive Health. This was challenging a state limit on funding for abortion. And the Pennsylvania High Court actually overturned its earlier precedent that had upheld that ban on funding. And this decision was focusing on a sex discrimination standard under the state ERA. So it didn't reach a inherent or a fundamental rights claim that was also presented in the case, but still the majority made a point of rejecting an originalist approach that would apply if the inherent rights claim was to come back in later litigation. And they simply said, we're not constrained, as the Dobbs courts believed it was, to determine whether abortion is deeply rooted in history or traditions of the Commonwealth. That is not our Constitution's analytical framework, since our Article I rights are inherent. So I think that's a pretty clear statement, like we're not doing a different Dobbs or originalism, we're doing a different approach under ours. And even, more pointedly, there's a concurrence by Justice Weck that goes in great detail about all the problems of applying an originalist approach. And so I won't quote because there are lots of fun quotes from these opinions, so it is really worth people looking at them. But one part of that raised a kind of a different question than some of the ones Mitra already quoted, or rather posed the question was, it's a failure to look beyond the shallow factual record if we don't examine the, quote, whys that drive historical analysis. So simply referring to criminal laws that subjugated the rights of women in the past as a basis to subjugate the rights of women today without looking critically at them is not getting at what was going on. And it's just interesting because several months later, so this was a 2024 decision, the Utah Supreme Court also issued a decision under its state constitution in an abortion abortion challenge. And it really echoed that language. There's language asking again, we need to understand why Utah banned abortion at the time of statehood and what that can tell us about how Utahns who voted for the Constitution into existence understood the relationship between them and their government. And we can use this history to help define the principles the Utah Constitution contains. And it goes on and it gives example that interracial marriage was banned at the time. And the question is, why was that? And is that something that is consistent with our constitutional principles? So those are two examples of state Supreme Courts that struck down, whether preliminarily or finally, restrictions on abortion, and doing so in ways that really did raise questions about originalism as an acceptable method.
So I want to tease out something that you kind of alluded to when you were talking about the Pennsylvania courts and some of their decisions around the ERA and the claims that were brought. I mean, we at the federal level don't have an ERA. So is there a tension between the project of originalism and the important or different role state constitutions and state courts have, and especially when you compare them to federal courts and the federal Constitution?
Happy to respond to that. I think, as Mitra was discussing, right, these state constitutions have provisions enacted at different times over many different years. And so, yeah, there's many reasons states courts have not to transplant the originalist theory onto those unique state constitutions and histories. And if you go back to kind of the original explanation of originalism, it really was created around this idea of like our founding in the US Constitution. So in many ways, it wasn't even designed and doesn't make sense in the context of a lot of state constitutions and in state histories. So if you think about it, the constitutions of our states were enacted across a span of like wildly different time periods in our national history. If you look at America as it stands today, it's vastly expanded geography and the demographics that didn't exist at the founding or even during the Reconstruction period, right? It changed a lot over these hundreds and hundreds of years. And so that, in addition to the amount of amendments and different kinds of ways that state constitutions developed, makes it, I think, a real tension to bring this idea of we can find a singular public original understanding to interpret the one true meaning of the Constitution. And if there's time for a quote, I would quote Professor Hirschkopf. She's a scholar of state constitutional law. And the way she put it was, America expanded across the continent and fits and starts swallowing legal subcultures as the nation took shape. In a system composed of 50 interconnected legacies, there's a fundamental problem with the Supreme Court's brand of originalism. It obscures the deep pluralism that marks the nation's true history and tradition, which should be respected and even celebrated. And then going back to what Mitra already addressed, and she can talk about it more, as a practical matter, it sometimes just does not work. It's sometimes impossible to find the types of records and historical evidence that you would need to do originalism. Not every state has the National Archives. They didn't even all have complete convention records during the ratification. So you might want to comment that, but it's really impractical.
Mitra, care to jump in?
Yeah, I'll just add, with a lot of state constitutional amendments, a lot of those are passed by ballot initiative. That's not in every state, but some states allow that. And so if you want to get into what the original public meaning of an amendment to a state constitution is, that can be very hard to dig into, because how do you know why voters voted for it? They didn't provide a reason on their ballot or anything. So sometimes there are some sources like ads or pamphlets or something in favor of a constitutional amendment, but that's not always the case. And so, you have the fact that it was passed as evidence that voters wanted it to pass, but you don't have all of these sources. And so it is just very hard to really be able to say that anyone knows now what the original public meaning, or that there was one singular original public meaning, as Diana said, at any given time. And we just don't know why voters voted for something. And so that is, I think, a real challenge with trying to rely on original public meaning here.
Well, state constitutions are much more expansive in the rights that it gives its citizens in a way that the federal constitution isn't, as you both have highlighted. So I want to stick with you for a moment. We had a very tumultuous recent set of federal elections. How do you see this affecting current or potential litigation in states?
So for the last 2 years, we've been dealing with the fallout from Dobbs, and a lot of the litigation to protect abortion rights has really been in the states, challenging those abortion bans in state courts. With a new administration that is likely to be more hostile to abortion rights, we're likely to see some threats coming from the federal level on reproductive rights more broadly, which would require litigation in federal courts. So that could be at the administrative level, regulations that HHS might pass, could be something Congress does. One of the major concerns is also that the new administration will try to revive a 150-year-old zombie statute called the Comstock Act and use that to prevent people from accessing abortion care nationwide. And so this is an anti-obscenity law from 150 years ago, prohibits the use of mail to send anything that is considered obscene, which could include medications and other articles used for abortions. Anti-abortion advocates have indicated that they think the new administration could use that or could just start enforcing it, which, to be clear, is not consistent with the prevailing interpretation from courts or the Department of Justice about this law, but there are certainly concerns that the new administration will try various tactics to try to undermine existing rights and really try to roll back those rights even further and try to set us back to, 150 years ago.
Now, in addition to the federal Comstock, some states, if I understand correctly, have state Comstocks. Is that correct?
Yes, I believe so.
Yeah. And is that a concern as you think about what litigation looks like in the future in some of these states? And that is it going to compound?
I think it certainly could be, a concern. And, at the state level, we're also always just watching with new legislative sessions beginning to see what's going to happen there. So there could be, of course, new laws in many states. And so we're not abandoning state courts by any means, although I do think there will be more of a shift to abortion rights playing out on more in the federal courts than they have been for the past couple years, given everything that's happened post-Dobbs.
Mm-hmm. And what about the threat of a national ban on abortion access?
Yes, that is certainly something that we are watching out for and are deeply concerned about if Congress were to try to pass a national ban.
And anything you'd like to add?
I think maybe just two thoughts on the Comstock potential enforcement. I think Mitra explained it perfectly. I would just highlight, right, it's really a perfect example of this originalist project, taking and really revising a law and a history in a way that claims it's true to the original understanding of that law, but it's really just a justification for modern day political ends. As Mitra was saying, this was a part of a purity campaign to curb sexual obscenity, non-marital sex as indecent, filthy, or vile. And as Comstock was originally understood, it was a First Amendment nightmare, right? It totally changed what First Amendment law looks like in a response. We wouldn't tolerate it today. And even if it was originally understood, to limit distribution of these things that were considered obscene or vile, it was never understood to regulate healthcare nationally or to ban abortion nationally. It always allowed for healthcare, including abortions that were necessary for health reasons. So that, original meaning is vastly different than how they are looking to use it today. And when I say they, I mean, look, the Vice President-elect, J.D. Vance, he did join a letter in 2023 demanding that DOJ use Comstock to shut down telemedicine. And it's exactly the strategy that's proposed in Project 2025. So if that was followed up on, you would see the effects Mitra was describing. And again, it would be this modern day policy objective end goal, really not reviving, but revising the Comstock Act into something it never was intended for. So in that sense, a hypocritical version of originalism, I would say. And then as you both were just discussing the potential for kind of national impacts and a national ban, I guess the one thing we have to be clear about is all the amazing progress and jurisprudence that come out of state courts and state constitutions applies only in those states. They can be influential and inspire other states to do the same. But if we do see a national ban or something effectively used as a national ban, federal law and federal constitutional law does preempt. So that is a real risk.
So Mitra, with all of this this picture that, you and Diana have been painting, what are some cases and courts we should be on the lookout, at the state or federal level?
So first, as Araceli pointed out earlier, the North Dakota and Georgia decisions that I was talking about earlier are both from trial courts and are being appealed right now. And so I would definitely recommend that folks follow those to see what happens and to see how those state Supreme Courts pick up on those arguments that the trial courts were making about using history and tradition to be more informative rather than trying to discern a really narrow original public meaning there. We had another very similar case in Idaho that went to trial in November 2024, challenging 2 abortion bans there. And we are still waiting on a decision there, or the trial was recent, so we are waiting on a decision there. And Idaho is a state that has its state Supreme Court has really relied on a pretty originalist approach to determine the scope of constitutionally protected rights. And in a January 2023 decision, the state Supreme Court there found that there's no general right to abortion protected by the state constitution. So in our challenge to Idaho's current abortion bans, which we brought on behalf of physicians and patients who had health issues arise during their pregnancy and weren't able to get care, we are challenging those laws because even if there's no general right to abortion, plaintiffs are arguing that there should be a limited right to obtain an abortion when a person's life or health is at risk during their pregnancy. And so that was a 2-week trial that ended pretty recently with very compelling state testimony from patients who were harmed by the bans, and also with testimony from experts, including a historian, to provide that context as to what the history and tradition of Idaho allows. And finally, I wanted to alert everyone to a case that was filed in Arizona at the beginning of December 2024. As I'm sure everyone has heard, there have been, several states passing, or several state electorates rather, passing initiated measures and ballot measures to enshrine abortion rights in their state constitutions. When those measures get passed, it's, if there are bans and restrictions on the books, they don't automatically just disappear. So either legislators have to go in and repeal them, or they get challenged in court and found to be unconstitutional under the new provisions. And so that's this case in Arizona. Arizona voters passed a constitutional amendment creating a right to abortion in the state constitution in November 2024, but there is still a 15-week ban on the books. And so there is this new lawsuit seeking to get a declaration that the ban is unconstitutional and an injunction blocking its enforcement.
Very exciting. Some bright spots. So Diana, what about other decisions impacting fundamental rights? Any on the horizon that we should be on the lookout for?
Oh, other state courts cases to look at. Sure. I mean, I would just add in the area of abortion challenges, I would just flag pending decisions from Wisconsin and Wyoming. There's cases that have been working their way to the Supreme Courts there, and I flag them because neither of those state Supreme Courts has previously issued any decision interpreting the right to abortion under their constitution. So those will be real opportunities, hopefully, right, for those state courts to show how interpretation of their constitution is different than what we saw in Dobbs. And actually, there was oral argument in the Wisconsin's case recently, and one of the justices, the Supreme Court justices, pointed out that the law was enacted at a time when only white property-owning men had the right to vote, right? So it's already coming up, this, concerns about what happens when we use originalism. In the other case I said is in Wyoming, and there a trial judge recently struck down the state abortion ban and based that in part on the Affordable Care Act era constitutional right to healthcare freedom. So that's very interesting because it's one of these newer provisions and amendments. It doesn't make sense to apply originalism as it is, kind of conceived, to our founding and ratification. But that's another one, assuming it reaches the state Supreme Court, it would be a major new precedent and opportunity to set out an independent judicial approach in Wyoming. But I would say it's also going to be instructive to see the progress of gender and trans rights cases. So obviously there's a lot of attention and concern right now on how the Supreme Court's going to decide the equal protection case raised in Scrimeti, and that was challenging Tennessee's ban on gender affirming care. And that's, of course, going to have a very huge impact on sex discrimination claims nationwide. It'll certainly really control them in the federal courts, but it may influence how state courts dealing with sex discrimination claims apply those in abortion or gender or trans cases. But they're also an opportunity, as we saw post-Dobbs, for state courts to take a different route when they're interpreting their state constitution. And a lot of the pending cases have other types of claims that were not argued to the Supreme Court in Scrimeti. They're grounded in privacy and autonomy and rights to health. So we're going to see how those play out. And another opportunity, I hope, for state courts to set forth an independent approach to constitutional meaning and interpretation.
So be real trendsetters. So we're getting close to ending our time together. And before we do, I want to ask each of you for a call to action for our audience. I think people have been very enriched by this conversation, and I'm sure they're going to feel motivated to do something. So, Mitra, what would be your call to action for our audience?
Yeah, I would say to anyone who practices in state courts, really get to know what your state court or what your state Supreme Court's philosophy is around applying originalism without assuming that they necessarily take a very strict originalist approach. As we've talked about today, a lot of state courts don't. There is a lot of, I think, flexibility to develop arguments where we're using history and tradition in a way that doesn't necessarily restrict people's rights. And that is more, I think, true to what a lot of drafters of state constitutional or state constitutions intended, which is to create a document that would evolve and cover people as the state evolved. So yes, I guess just don't assume that you are bound by certain arguments just because they come up in certain courts, and remember that each state has its own rules and its own kind of flexibility to take different approaches.
Great. Diana?
Well, I'm going to say something I thought Mitra might have said, which is with so much being decided at the state level, I think there's really a need across the progressive legal movement, even with amazing national litigating groups like the Center for Reproductive Rights, from support from attorneys and judges and academics with expertise in state courts and state constitutions and state history. Often, as Mitra was talking about before, you need these people as experts or maybe local co-counsel who really knows the rules and in and outs of their state court. So I think whether you have that experience yourself or people in your personal and professional networks do, think about how you or they can engage in ways that would support the communities and advocates that are taking these really rights protecting cases to state courts, in addition to doing them in your own work. And I think I would just add, from my perspective at UCLA Law School, really think about helping to mentor, to educate and train the next generation of law students wherever you're coming in contact with them, and as well as supporting colleagues you think would be terrific state court judges, and considering that as a next step in their professional career.
Amazing. Well, thank you for watching and engaging with our program. Thank you to our participants. You're doing real critical work, and we thank you for taking time out of your schedule to share your expertise. This series will continue throughout the year and address other significant components of reproductive rights. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at americanbar.org/CRSJ. Thank you for your time with us today.